Hi, Gary DeWaal here, and this is Bridging the Week, January 20th to 24th, and today is January 27th, 2014. Good morning. Top accounting firms were in the bullseye of regulators' attention this past week. One, KPMG, settled with the U.S. Securities and Exchange Commission over an allegation that it compromised its independence when it provided various non-audit services to affiliates of various clients, as well as loaned one ex-employee to an affiliate of an audited company where he acted as an employee of that company for certain material purposes. Also, 4 affiliates of U.S. top accounting firms were barred for 6 months from auditing China-based U.S.-listed companies because they failed to comply with documents requests by the SEC. The firms had claimed they could not comply with such requests without violating China law and procedures, including privacy regulations. These stories and more make up this week's version of Gary DeWaal's Bridging the Week, so let's get started with our review. The U.S. Securities and Exchange Commission alleged that KPMG violated its rules related to auditor independence by providing non-audit services to affiliates of 3 public companies it was auditing from 2007 through the end of 2011. The services provided including bookkeeping, payroll, and expert services. Some KPMG personnel also owned stock in one of the relevant public companies and an affiliate of another. In connection with one affiliate, KPMG also hired a retired former senior employee and then loaned the individual back to the entity to perform the same tasks he had done as an employee, effectively acting as a manager, employee, and advocate for the affiliate. KPMG agreed to pay in excess of $8.2 million to settle this matter. Simultaneously with announcing the settlement, the SEC issued a separate report advising audit firms that they may not lend staff to audit clients in a manner that makes such employees tantamount to being company employees. Separately, an SEC administrative law judge banned the China affiliates of 4 top U.S.-based accounting firms from performing audits of U.S.-listed Chinese companies for 6 months for their failure to produce certain work papers in connection with investigations into such companies. The SEC was reviewing such companies for possible accounting fraud and served requests for documents on the respondents at various times between March 11, 2011 and April 26, 2012. The 4 firms that were barred from appearing or practicing before the SEC for 6 months were affiliates of Ernst & Young, KPMG, Deloitte Touche, and PricewaterhouseCoopers. A 5th accounting firm, BDO China DeWaal CPA, was named in the relevant SEC action, but solely was censored. The accounting firms had failed to produce the requested documents for fear of violating Chinese laws and procedures relating to producing documents to oversee regulators, including privacy requirements. In China, each of the accounting firms is licensed by the China Securities Regulatory Commission, and all but Deloitte Touche by the Ministry of Finance too. Respondents have 21 days to request a review by the Commission. The initial decision issued by the SEC Administrative Law Judge does not become final until the Commission issues an order of finality. I have read separately that the CSRC is not happy with this decision. No surprise there. Nothing worse than being caught between a rock and a hard spot. Last week, the U.S. National Futures Association announced that it is seeking comment regarding a possible new requirement that registered commodity trading advisors and commodity pool operators maintain a minimum amount of capital, much like futures commission merchants and non-guaranteed introducing brokers currently are required. Currently, CPOs and CTAs are not subject to any capital requirement. In addition, the NFA seeks advice on a number of other possible new customer protection measures involving CPOs, including whether an independent third party should be required to review and authorize a CPO's disbursement of any pool funds. A CPO should have an independent third party prepare or verify account statements regarding a pool's value periodically throughout a year, and whether an independent third party should be required to prepare or verify a pool's performance results. The NFA also seeks views regarding how might pool assets independently be verified in a manner similar to how FCM customer balances at their depositories are now compared daily by NFA and the Chicago Mercantile Exchange with FCM reports to identify discrepancies, and how to handle inactive CPO and CTA members. Comments are due by April 15, 2014, although curiously, the NFA is seeking comments proactively only from CPOs and CTAs. I have a hunch they'll accept all comments, however. I am hearing some unhappiness with this comment solicitation by the NFA. Why fix what's not broken, I am being told. But customers are being hurt by less than reputable CPOs and CTAs who mishandle customer funds and commit other fraud. What to do? That's all the NFA is asking, and it's a good discussion they are prompting. Just keep in mind, these bad guys tarnish the reputation of entire industry, and if there is a sufficiently large blow-up, it won't be the NFA, but Congress that tries to impose a solution. Last week, some additional interest rate swaps were deemed self-certified by Truex LLC, a swap execution facility. The swap self-certified will be mandated to begin trading on or subject to the rules of a designated contract market or swap execution facility as of February 21, 2014, whether on Truex or another qualified execution facility. 2 weeks ago, you may recall, the CFTC deemed certified certain interest rate swaps proposed by Javelin CEF that must begin trading on or subject to the rules of a DCM or CEF as of February 15, 2014. Separately, the CFTC created an interdivisional staff working group to review certain swapped transaction data, record-keeping, and reporting requirements. Under the direction of the Division of Market Oversight, this group is required most immediately to publish by March 15, 2014 for public comment questions related to compliance with applicable reporting rules and consistency by market participants regarding regulatory reporting. Oh yeah, and on Tuesday, the scheduled Technology Advisory Committee chaired by Commissioner O'Malia was canceled. It is now rescheduled for February 10th. If only I had known this on Monday night before I traveled down to attend. Oh well. The U.S. Board of Governors of the Federal Reserve System last week issued its heightened supervisory expectations for 8 domestic bank holding companies in an effort to blunt the effect of one of these very large firms' failure on the broader financial system and economy. These expectations relate to the firm's practices and procedures related to collateral management, payment, clearing, and settlement activities, liquidity and funding, management information systems, and shared and outsourced services. Separately, ICE Clear Europe submitted to the Securities and Exchange Commission for its approval proposed amendments to its rules related to recovery and orderly wind down in case of a clearing member default that could result in exhaustion or potential exhaustion of its resources. These are important rule changes that are aimed to help clearing members cap their potential liability to ICE Clear Europe, so well worth reviewing. I've got a link on the article version of my website. Last week, the European Court of Justice upheld the authority of the Council of the European Union and the European Parliament to vest certain powers on the European Securities and Markets Authority under an EU regulation that permits the EU to adopt measures to harmonize short sales across member states. On March 25, 2012, ESMA was empowered with extensive advisory, notification, and regulatory powers with respect to short selling. In response, in May 2012, the United Kingdom challenged this authority, claiming that ESMA had been given too much discretion of a political nature that conflicted with EU principles regarding the delegation of powers. The court rejected this argument, claiming the authority granted to ESMA related to short sales did not go beyond powers granted to the agency when it was created and was sufficiently limited. Aren't fights within a family fun to watch? Not really. And finally, the UK Financial Conduct Authority fined Standard Bank 7.6 million Great British pounds or 12.5 million US dollars related to deficiencies in its anti-money laundering policies and procedures regarding corporate customers with ties to politically exposed persons. In the UK, politically exposed persons generally are individuals who at any time within the prior year would be considered a prominent public official or an immediate family member or close associate of such person. This failure by Standard Bank lasted from December 15, 2007 through July 20th, 2011. During this period, Standard Bank had 5,339 corporate customers, of which 282 were linked to politically exposed persons. However, prior to establishing business relationship with these customers, the bank failed to carry out adequate enhanced due diligence or conduct adequate ongoing due diligence. FSA considered the bank's conduct particularly serious because, among other reasons, it provided loans and other services to a large number of corporate customers from jurisdictions regularly identified as posing a higher risk of money laundering. Ouch! Well, that's it for this week's Bridging the Week. As always, there are always more meat on the potatoes, or meat on these articles, on the article version of Bridging the Week on my website. And there's some additional stories too, so check them out. Until next week, this is Gary DeWaal. Have a great week, and ciao.